streaming dashboard. Click on that to make sure we're good. Okay, now go back to YouTube. And that window there,
that
yep,
one.
and go back to your live stream. And there we go, we're going live. All right.
So then when we start, I'll click this off. So it'll go back and forth. And then I'll start this.
And then when everything is done, click it back to Judge. So when you gavel out.
Getting ready to move to go.
Looks like
Your little
tablet thing.
Oh, it's on that side, so we're good.
Thank you so much.
You're welcome.
Morning.
Good to go.
Okay. Do you want me to tell them that we're ready, or they'll come out?
They know we're good to go. We have three.
all rise. The Honorables, the Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you, and good morning. Oh, beautiful. And welcome to the Court of Appeals. Your panel this morning, we've got so much equipment up here now that there's not room for the stuff we actually need. Okay. I'm Chief Judge Donna Stroud, head of your panel this morning. To my right, we have Judge Lucy Inman. To my left, Judge Jeff Carpenter. We have two cases for argument today, and of course those are related cases. And so we had thought about, obviously normally each side has an hour for their cases, and we're going to stick to our normal schedule as far as that goes. Two cases and the times as normal as far as what's allowed. But we realize that with the related cases, and of course they do present separate issues or separate cases, but we'll be flexible depending upon, however we need as far as dealing with that. We're going to do the live stream of the two cases as just a continuous one of the whole thing, because of course all of our cases are live streamed now, and instead of splitting it in the middle and stopping that, we will split it in the middle and stop as far as the timer goes and all that, in our case. But just to say, if use as much or as little time as you feel that you need to use. It is always perfectly okay with us if you don't use all of your time, but if you need to use it, that's fine too. So, because like I said, we debated whether or not the time should be less, but we just decided to leave it as is, and then you can use it as needed. And of course, there may be questions, and that of course uses up time as well. So, and as far as, so before we begin, we have the timer set automatically for 5 minutes of rebuttal. If you would like to change that, let us know. We can do that. Is that?
6 minutes. I would
6?
prefer 6.
Okay, very good. Then we will set it for 6. Okay. Okay. So with that, any questions about how we're going to deal with that? Okay. Well, we will go ahead and proceed then.
Well, good morning, Chief Judge Stroud, Judge Inman, and Judge Carpenter. May it please the court. My co-counsel, Mary Euler, and I represent the appellants in this declaratory judgment action, which I'll refer to as a DEC action, and we are privileged to appear before this court.
Mr. McGuire, if I can just interrupt you from the get-go with a question. If this panel agrees with your arguments and reverses the order of the trial court denying your motion for judgment on the pleadings and granting the defendant's motion for judgment on the pleadings, are you asking this court to reverse and remand the matter to the trial court to enter judgment on the pleadings in your client's favor?
Yes, in the declaratory judgment action.
Very good. And then second question, you don't have to, just this will be on my mind throughout this morning. As a practical matter, is there any difference in what your clients are seeking to achieve in the DEC action and what they are seeking to achieve in the caveat proceeding?
The ultimate result, no. In the declaratory judgment action, it would happen as a result of a different vehicle than it would in the caveat, but the ultimate result would be the same. And I might add, I think we would believe that if the declaratory judgment action be entered in favor of our clients, that would moot the caveat hearing or caveat claim.
Thank you. Answered another big picture question.
Okay.
Fine. Thank you.
And our clients, or the appellants, are the 4 siblings of the decedent, the testator, Frank Magestro. They are Andrea Parks, Justin, Dion, and Leah Magestro. And the appellee, Peggy Johnson, is the sister of the testator's divorced wife. And for clarity, I will refer to the testator off and on as Frank, his divorced wife, Carol, and the appellee, Peggy, with no disrespect, but it's purely for clarity. We believe that this matter is a statutory issue depending upon 31-5.4, the statute that has revocation by divorce or annulment. Of course, in this case, it would be by divorce. And that statute, according to the annotations, has only been cited in 3 cases in North Carolina, and 2 of them seem to have something to say, the other one not. One of those cases is the Gaboni case from this court in 2005, and the Gaboni case says that the language of 31-5.4 revokes all provisions in the will in favor of the testator's former spouse. And Gaboni explained that statute by saying that it clearly mandates that unless the testator expressly indicates in his will that even if he divorces his spouse, she would remain a beneficiary, the former spouse is denied any testamentary disposition. That's the impact of the statute before you. And we have framed our declaratory judgment actions in the alternative as to whether or not the phrase "in favor of" the testator's former spouse, whether that would be in favor of his former spouse, in this case Carol, or not. If it is in favor of his spouse, Carol, then the whole item 4 would be revoked. But we think the better case, which is the first count of our declaratory judgment action, is that, in fact, item 4 is not in favor of Carol, the former spouse. Therefore, the statute does not apply. The condition precedent does apply, but is unfulfilled, and therefore the case is distributed according to intestacy, according to the way we would read the statute.
And just to be clear, the statute that you're arguing ultimately governs is 31-42. Is that correct?
That would be
failure of devise by lapse or otherwise.
correct.
Okay.
And that would be the vehicle, as we were saying earlier, in this case,
Okay.
to get to the intestacy. So the statutes, with the language leading into it and a little that doesn't apply here, is simply whether it revokes all provisions in Frank's will in favor of the testator's former spouse. And our argument would be that that is not the case, that in particular, item 4 does not favor Carol. The beginning of the item 4, and let me first maybe run down the will just to let you know, we think this will makes perfect sense from a viewpoint of Frank without giving any thought. He gave no thought to a divorce, and that may happen in a lot of situations where the testator is relatively recently married. And in this case, you all will remember the will has I think 5 or 6, but the key provisions would be item 2. And in item 2, Frank said, I want to leave everything to Carol, my wife, and that makes perfect sense. That is revoked by 31-5.4 because she did not predecease him. Then you have item 3 and item 4, both of which, using a little bit different language, discuss the question of whether the condition of where Carol, his former wife, would predecease him. And in item 3, he left, after 2 leaves everything to his wife, it's revoked. Item 2 said he was leaving everything to his kids, but there were no children of this marriage. So the first bequest to his wife is removed by statute due to the divorce. The second bequest to his kids is removed because they didn't have any kids. And that gets us to the third and last of the bequests in Frank's will. And that is the one that is before your honors. And it says, in the event my wife should predecease me, those 11 words we need to look at in the context of this statute, and in our minds, the statute does not revoke any portion of item 4 because item 4 is not in favor of Carol. The statute only applies by its terms that if it favors the deceased wife. And what item 4 says, it has a if Carol shall not be alive at the time of my death, but then it goes on to spell out in that 2 particular requests. One of them was to Elizabeth Chambly, who was Carol's mother, now deceased, and the other was to the testator Frank's parents, also now deceased. That's why without children and without having been divorced, that's why our clients are the siblings, whom we would argue are the natural bounty of the testator's being family, as opposed to former in-laws. We would say that in North Carolina they have the special bounty of the testator. So when you look at the question of whether or not Carol, this will is in favor of Carol, which is the statutory test, first of all, merely having a condition precedent as to whether or not she survives, that alone, it's not a provision, it's a clause in the provision, and that doesn't benefit her one way or the other. How someone else might receive a bequest, given that she's not able to under the statute, that doesn't benefit her or help her one way or the other. So you look at what the bequest says would happen if the condition precedent is not fulfilled. And in that case, it's to his in-laws or to his parents. Well, clearly, Carol does not benefit by something going to her former husband's parents. That one's easy. But I think the other one is as clear, if not quite so easy, and that is that a bequest to Carol's mother does not benefit Carol. And when the statute says, very, very plain language, in favor of the former spouse, that language should not be able to be expanded by a court because it's completely clear. When it says in favor of the former spouse, it would add words to the statute to say in favor of the former spouse and his or her mother or father or sister or kids. And that makes, again, perfect sense in the North Carolina where we look at the four corners of the will and try to decide according to that who would be the natural beneficiaries or objects of the bounty, and it makes every sense that that would not be your former in-laws. In fact, the cases, I don't think I've seen a case that would say the natural bounty of a testator is the former in-laws. We did cite a case where it would say the sisters would be, which in this case there are 3 sisters and 1 brother of the testator, happen to be our clients. So that issue we would argue a couple of ways. One is, and these were additional authorities we provided to the court, one of them was just the plain language that you use in looking at a statute. Webster's Third International Dictionary defined in favor of, the words of the statute, as meaning to the special advantage or benefit of. Well, having your mother, your brother, whatever, aside from the fact the statute is completely clear, it says the former spouse and only the former spouse, but the definition that we would use would be to the special advantage or benefit of. And having some money or some bequest go to one's the mother-in-law would not be in favor of Carol. And the one case that we were able to find, we could not find a North Carolina case, as I mentioned, there's only been 3 that have cited this statute at all, but was the Supreme Court of Texas case in 2007, the Estate of Nash case. And it specifically, well, first it began with language that I think is completely helpful in this case. The Supreme Court of Texas said, while death is certain, divorce is not. In this case, the testator anticipated the former, but did not prepare for the latter. So he took care of his death, but, you know, in the rush, been married, didn't ever think that that would fall apart. And so the question in the Nash case was whether or not the testator's former stepdaughter, this is stepmother, would be in favor of the testator. And the Supreme Court of Texas said no. The question presented here is whether a contingent bequest to the testator's former stepdaughter, in this case mother-in-law, is a provision favoring the former spouse. We conclude it is not and affirm the Court of Appeals, which allowed the condition to go into effect and prevented the bequest.
I have another just question that I don't want to take up time that you need, but I think we'll be fine. The circumstances of this deck action being brought, and I'm particularly looking at the amended, this is in the caveat proceeding, but I will just say it goes back to the circumstances of this deck action being brought. Frank's sister thinks he doesn't have a valid will. Frank's sister and brothers go to, with the intent of opening up an intestate estate. Am I right? And they get there and they find, I mean, this could be out of a novel. They find that anonymously someone has sent to the clerk of court the will that names Carol as beneficiary and her family members as contingent beneficiaries. Should those unusual facts, how do those unusual facts, if at all, play into the analysis that you think that we need to do here?
In the caveat matter, which we'll go in more detail later, I think they and other facts form the basis of the caveat.
But in this matter, that's the factual background of both cases. So I'm just asking, in this matter, does that factual background have any bearing on the court's analysis?
None that come to mind, and I might even add that those facts were not in the declaratory judgment action. You know, it was first, and those facts we pled in the caveat. So I'm not sure that...
those would be facts outside the record.
Exactly.
And leads to another question I have, which is, how is your argument that the trial court should have entered judgment in your favor consistent with your argument that you should have been allowed to introduce evidence outside the pleadings? I mean, what evidence outside the pleadings did you need to present, and how is the trial court's ability to grant judgment on the pleadings frustrated by your inability to present some other evidence?
The court should not allow extrinsic evidence because in Frank's will, the intent of the will should be determined by its four corners. And we did object to the fact that in the declaratory judgment action, the trial court did hear other matters and actually put in his order, which I understand you all are disregarding because it's on a motion for motion for judgment on the pleadings. The court is not to draft findings or conclusions. They are to be disregarded and even stricken. And then in the brief, the other side added additional facts, and I think we kind of let the court know that there are a lot of facts out there. But in terms of our position, we think that it would be a matter of judgment one way or the other.
But this court can't find facts, you know that?
Exactly.
We can't find facts, and I'm just trying to establish that you're not taking the position that there are more facts that are needed or further proceedings that are needed to decide this case.
No, we are not. And I think that we were making just a response that it seemed like the judge and the other side were throwing in facts, and we wanted just to let the court know there are a lot of other facts out there, but we do not think that this case should be remanded for a factual issue because it's on a motion for judgment on the pleadings, and the intent of the testator, Frank, is to be taken from the four corners of the will. So extrinsic evidence would actually not be competent. So we're actually asking for a declaratory judgment in our favor, not a remand for facts that would actually not be proper for the court to consider in this case. So I think where I was going with that was at the point of saying that under the statute, it requires a provision that was in favor of Carol, and item 4 is not in favor of Carol because it benefits Frank's family, and benefiting her own mother is not what the statute asks for, and we think that it would not be right to engraft upon the statute when you say the former wife's whatever. That would not be consistent.
Could Carol bootstrap to a better position by her mother inheriting and then dying, and then Carol inheriting from her mother?
I didn't follow that question.
By operation of law, any provisions in favor of Carol are revoked
Correct.
per statute. Could Carol's mother die, and then Carol inherit from her mother to bootstrap back to the position?
No, that would clearly be in violation of the statute because it would benefit her. So if this
That's kind
condition...
of my point, is that a valid argument that it could benefit Carol?
Not with the statute being applied to the will.
It's different than the Nash case that you cited where the daughter, one wouldn't presume to inherit from one's daughter.
Well, that's true. But the statute keeps Carol from getting any disposition. So even if...
As to Frank's will, but the scenario that I'm posing to you is Carol wouldn't be getting from Frank's will. She would be receiving from her mother's estate, assuming that her mother predeceased her, after inheriting from Frank.
That would be correct. But in terms of what is before the court today, the item 4 is a condition precedent, unfulfilled, so it doesn't go to Carol's mother that she could then inherit that way.
We're talking about two different things. I was talking about the in favor for language. You're referring to a condition precedent.
Okay.
There's a little different approach in my mind.
If the will provides an item 4 that Carol's mother takes, if Carol predeceases Frank, then would it in fact be impossible for Carol to take, by inheritance from her mother, any proceeds from this will that her mother received?
It would, although if the mother predeceased, Carol's mother predeceased, but for the unfulfilled condition precedent in item 4, if that happened, then it would be distributed to Ms. Chambly's children. Peggy Johnson is one of those. Carol is not in the case because of the statute.
But I'm just trying to point out that Peggy Johnson is Ms. Chambly's only surviving daughter.
Correct.
Or no, Carol is surviving as well. But in other words, for Ms. Chambly or for Peggy to take, the will provides that Carol has to have died.
Correct.
Okay, thank you.
And so we would conclude that the best argument in the case, and there should be, that the clear reading of the statute in favor of the former spouse should be that and no more. And if you went the other way, we think the other side is in kind of a catch-22. If item 4 doesn't benefit Carol, as we argue, but if it were the other way and it did benefit Carol, then all of item 4 would be stricken by the statute. Our argument is it doesn't benefit Carol, according to the Nash case and according to a direct reading of the statute. But if it were otherwise, then the statute would take out or revoke the entire item 4. That's our alternative claim in the declaratory judgment action, but it's not what we think the clear reading of the statute, the ordinary meaning of in favor of, and the Nash case would say, understanding there is that difference in the in the Nash case. Given that, then the question is, if that condition precedent is valid, then that doesn't apply, and it goes to intestacy under that statute. And this is where the case law that we cited, starting with the Betts case, which would indicate that the failure of the condition precedent causes the lapse of the gift in item 4. And North Carolina courts have repeatedly held that they found intestacy when a residuary clause is expressly made subject to an unfulfilled condition precedent. And that's the situation in this case. In those cases that we've cited were the Betts case, the McKinney case, Grant case, and the Hammer case, two of those being Supreme Court cases. And in each of those, they said, well, there is a presumption of intestacy, but when you have a will that is clear, that is not applied. And that is what is the case here. The appellees tried to distinguish this case by saying, well, in Betts there wasn't a divorce, but that difference doesn't make a legal distinction, because the question in Betts had to do with whether or not, if there's a failure of a condition precedent, whether it then goes into intestacy. And I think the strength of having 4 of those cases, only one of them was mentioned in the brief by the appellees, and that was Betts. But the series of cases all say that if the unequivocal indication is that there's a condition precedent, and that's very clear. I mean, I don't think anyone can argue item 4 doesn't begin with a condition precedent. Then the laws of the state say that it should go into intestacy. And I might add that the legislature probably gave a good bit of thought in setting out who recovers in intestacy. And that would show, we think, who the natural bounties of a testator would be. And it would go to the spouse, the kids, the parents, the siblings, all of which would be the natural bounty of the testator. And we say that would be true in Frank's will as well.
And let me just point out, you're into your 6 minutes, but just want to make sure you noticed your little light there.
I did not.
Okay, all right.
So I think I would just conclude by saying that we think that this condition precedent is valid, it was not met, and it causes the distribution to go into intestacy. Thank you.
Thank you.
Good morning, Chief Judge, judges of the Court of Appeals, and may it please the Court. I'm Dave Irvin from the New Hanover County Bar. I represent the appellee, Peggy Johnson, in this matter. I am not going to rehash a lot of law that I've already written that you can read at your pleasure. I am going to talk about some of the practical applications of what the appellants are asking this court to do and what that could mean for thousands, if not 10,000s, of wills in North Carolina from such point forward. We agree totally with the appellants. This is primarily a case that revolves around a plain reading of that statute 31-5.4. It's a bright line rule as to the effect of divorce on a decedent's will. And I will discuss a couple of the appellants' arguments, the main ones, mainly that being that the condition precedent argument which counsel just described, as well as the benefiting Carol or not, which we also discussed. But both of those arguments call upon this court to take some legislative authority here and create some additional law if we're going to move away from the bright line interpretation of statute 31-5.4.
Mr. Irvin, if I can just ask you a sort of opening question. To me, our case law is clear that the intent of the testator should guide our interpretation of a will. Do you agree with that?
I do, Judge.
It appears to me from the will that Frank intended for Carol to benefit from his will outright, and we only look at the statute you just mentioned because of their divorce, it appears that Frank intended for Carol's family to inherit under the will only if Carol predeceased Frank. So how does removing the condition precedent from the will and passing the devise to Carol's family when Carol has not died honor the testator's intent?
Well, Judge, again, thousands, if not 10,000s, or maybe more wills in North Carolina have very similar typical language.
But we're here on this case, right?
Correct. That is correct. But it can't be lost on what the court decides to do here today will have an impact on all these wills moving forward, and it's not generally the case where we're talking about extended family versus intestate heirs. It's generally the case where we're talking about my spouse, unless she predeceases me, and then to my children. Under their argument, if we take it exactly how it is moving forward, anytime there is a divorced spouse that is still alive, the children don't inherit under the will.
And
it
is it true that the children don't inherit under intestacy?
Well, they inherit under intestacy, but the testator in this case, or in many similar cases, leave everything to my spouse or then to my children. In intestate distribution, it could be shared with brothers, sisters, adopted children possibly, parents possibly, depending on how it works out.
So the children's share would be less by intestacy than by just getting it under the will?
It certainly could be, compared with everything to my children, yes.
So in other words, and forgive me, you probably know the intestacy law a lot better than I do. If someone dies and they have 2 children, and then they also have siblings, and they also have cousins, and they also have parents, and they also have ex-in-laws, how do the children share? What share do the children take in intestacy in that situation?
I am not a will and estates attorney. However, the structure that is set up by the legislature does call for division, and it does allow for...
So does the structure set up by the legislature diminish the shares that the children take in intestacy?
It potentially can diminish the shares, yes.
Well, okay, but if they had had children, then that would have fallen under item 3 of the will, right? Because item 2 was all to my wife. Then if that's revoked by divorce, if they had had children, then that would have kicked in.
That is correct. The only reason that we're arguing this, what appears to be this extended family drama, is because item 3 is not applicable because there were no children. But in general terms, testators more often than not have children.
Right, but I'm just saying as far as effect on other cases, it's a very common provision for people to have, to my spouse, and then if my spouse predeceases me, to my children. I mean, I'd say, and then of course a person either does or does not have children. But the concern about leaving the children out doesn't really, I would think would be rather uncommon, because I think most wills like that are going to say to my children, if in fact there are any.
And how would a precedent from this case, in which there are no children, how would precedent for this case, in which there are no children, control cases in which there are children?
Well, what the appellants are arguing is that this condition precedent is going to guide the distribution scheme as it goes down the line. If to my wife, unless she predeceases me, not being a condition precedent that's been met, well, it wouldn't be met in item 3, it wouldn't be met in item 4 under that theory. What the trial court said was the condition precedent does benefit Carol or any spouse, and it benefits the spouse by establishing and securing their primacy in any distribution scheme by being the spouse and being alive. Once they're dead, then it doesn't matter, but in this case, they're not. So if we're going to evaluate it that way, we would have to evaluate every will from this point forward. Do we have an ex-spouse, and is that ex-spouse living? And if the ex-spouse is living, then the children don't inherit under the will. If the ex-spouse is dead, then they do. We're creating a legal event, an unintended legal event by the spouse's death or non-death to affect other distributions, whether it's to the children, whether it's to the ex-wife's mother.
And why do you call it an unintended legal event?
Well, because the intent in the general will language is, I'm going to leave everything to my spouse, okay? But if my spouse is dead, I'm going to leave it to my kids or the SPCA or wherever we're going to go from there. It's not an intended legal consequence that if I get divorced and my spouse is alive, the rest of my devices don't matter. But if my spouse just happens to be dead, we got divorced and she died, then it does matter. That makes no sense.
How does the condition precedent in item 4 benefit Carol?
It's the condition precedent secures her position as throughout the entire document that she takes under the will ahead of everyone else, ahead of item 3, ahead of item 4. If there were 12 items, it could be ahead of all of those by the fact that she is living and she is the spouse.
Well, I understand that about item 2, right? That's just direct devise to Carol. And you don't dispute, do you, that the statute 31-5.4 results in revoking that provision, right? Do you dispute that 31-5.4 results in striking item 2 of the will?
31-5.4 results in striking any provision that benefits Carol, and it's our position that it strikes item number 2 because she's no longer, they're no longer married. And
So if you just look at item 4, how does Carol benefit from a provision that devises property only in the event of her death? If she's dead, how can she benefit?
Well, I don't think you look at it as a one individual item, item 4. I think you look at the condition precedent as a theory all the way through the will document, which protects her position of primacy as the beneficiary as long as she's alive.
So there's not a condition precedent in item 2, right?
Correct. But she is barred from taking it in item 2 under the statute.
Okay. And item 3, there is a condition precedent, but there are no kids, right?
Correct.
So, would you agree that 31-42, the failure of devises by lapse or otherwise, would apply to item 3?
Well, I don't think we get that far because as the trial court found, and our position is that the conditions precedent are inoperable. They're excised from the will with the blue pencil, just as any other provision that benefits Carol is excised from the will.
And again, how does item 4 benefit Carol?
Well, it benefits Carol as the theme throughout the will, that she is the primary beneficiary and no one else is going to take as long as she has not predeceased Frank. So the condition precedent protects her and benefits her all the way through the will as the primary taker under the will.
But how does that square? Never mind. Go ahead. I don't want to take up your time.
No,
your
thank you, Judge.
presentation.
Well, and I will distinguish it with the cases that the council mentioned. This argument and why I believe that it comes down on our side is found in the appellant's reply brief. There are very few cases out there, and the appellants went through and they searched where conditions precedent have been upheld in will matters to result in intestacy. And there were several. Betts and Parrish, the language was to my wife and then to my mother in life unless they both predeceased me, and then to these people. And they didn't both predecease, and the condition precedent wasn't met. McKinney case also, it distributes only if my wife survives me. The wife did not survive me. Therefore, the residuary lapse under the statute that you just mentioned. But what's common in none of these cases is none of them have had 31-5.4 applied to them. These are all cases where there was not a divorce. That's why this, in some ways, is a first impression case. How are we going to apply that particular statute?
Well, would you agree that we're supposed to interpret statutes in pari materia of each other?
I'm sorry?
That courts, the doctrine that courts should consider all statutes in relation to other statutes. In other words, not looking at 31.54 in a vacuum and not looking at 31-42 in a vacuum, but applying all of these statutes together in a manner that does not create inconsistency in the statutes.
Absolutely. But again, the 31-5.4 is a very bright line issue. Just as, and let's look at the issue of benefiting Carol. It either applies clearly that it benefits Carol, or clearly that it does not benefit Carol. There was some argument that the gift to the mother, or presumptively to the appellee, benefited Carol. But it doesn't benefit Carol. It benefits Carol because it mentions Carol, it says it benefits Carol, or we can extrapolate that it benefits Carol, because to look at it any way other than a very narrow interpretation of 31-5.4, this court would have to, again, assume a legislative function and determine where does the benefit end. Does it?
I have to keep going back to, if the condition precedent is that Carol is dead, then how does the devise that follows that condition precedent, how could it possibly benefit someone who is dead?
The devise does not. The condition does, and that's why the trial court excised it from the will in finding the declaratory judgment action.
So is it your argument that in divorce cases, the statute 31-5.4 displaces the operation of section 31-42?
It can, and it can, but it doesn't generally as a matter of law, no. What it does is it removes any provision in any will that benefits the prior spouse.
So in any number of wills that have the predeceased spouse as a condition precedent, and there's a divorce, you would ask this court to apply the bright line of 31-5.4 and to preempt by that holding the application of 31-42.
Exactly, because, Judge, these testators, they made a will. We can assume, and we must assume, that they did not intend to die intestate, especially when there is a complex distribution scheme like this one.
Well, doesn't 31-42 provide for that very possibility, that if there's a failure of a devise by lapse or otherwise, then the property passes by intestacy? In other words, doesn't this statute say, we know there's a presumption against intestacy, but here we, the legislature, are saying that when a condition precedent fails, the property passes by intestacy?
Yes, but again, what I'm not apparently being able to articulate fully is that we don't believe that the condition precedent failed. The condition precedent was removed as a benefit to Carol. The rest of item 3, which is not applicable, but the rest of item 4 does not fail, and it continues as Frank had set forth that it would. And again, where this really...
How does that honor Frank's intent?
Well, again, I would look at it again to the much more typical case, everything to my spouse unless they predecease me, then to my children. Under this condition precedent theory, that's going to go away. In this case, we're talking about a sister-in-law. Okay, it's a little more cloudy, but in general, if the court finds in favor of the appellant, the next time this situation arises, we go back to, we've got an ex-spouse. If they're alive, then it changes the distribution of to the children and throws it into intestacy. But if they're dead, it creates a legal event because they did predecease. So then we go back and we do go forward with the provisions in the will, leaving everything to the children. Based on the fact of whether the ex-spouse died or lived, we're creating a fictional legal event that was not contemplated by the testator when he was laying out what his wishes are going to be regarding his estate, based simply on whether did his ex-spouse die or not before him.
Well, so you say the condition precedent itself is like the benefit to Carol. So what if this fourth provision said, instead of giving half to her mother and, splitting it up that way, it was half to a charitable organization and half to a church or whatever? And we happen to know that, for purposes of a hypothetical, that Carol actually didn't like either of these organizations. She didn't like them at all. She would have never left a cent to those organizations. Is that still of benefit to her, that it goes to those organizations that she didn't like?
I don't think that has any bearing on who it goes to, and that's what I'm saying. If we're gonna,
That's what I mean. How do we interpret a condition precedent as benefiting her? So she's deceased, and somehow it's still benefiting her.
It benefited her during the time when the will was written, and it benefited her the entire time they were married.
Well, I mean, a will doesn't speak until death, right?
Correct.
And it could change every day until, how
That
does
is
it
correct.
benefit a person until the death occurs?
That is correct, but it protects her position as long as she's alive and as long as she's a spouse. Once she's no longer a spouse, then that statute excises it, which is what the trial court found.
Ask another hypothetical. Hypothetically, if Carol had predeceased Frank, and then Frank died, and I'll probably ask your friends for the plaintiffs this question as well. If she had predeceased Frank, and we have these same circumstances, and then Frank died, then I guess the hypothetical fails, I see, because it's impossible to divorce someone who has, well, no, they divorced. Assume they divorced. Let's assume that she died after they divorced. Would her mother and sister take under this will?
Yes, because that satisfies both sides of our argument. That satisfies the condition precedent that they're claiming, or it satisfies that she's excised one way or the other. Either way.
So either way, they take under this will, no matter whether
Correct.
Carol is alive or not, they take.
Correct. And that's what my problem with this argument is. It turns on whether the ex-spouse died before the testator or not, which has no legal significance and no significance in the testator's intent, because that's not why he was saying, if they predecease me. That was a distribution scheme. Why should this turn on whether the ex-spouse died a day before or a day after the testator?
Well, isn't that the case in so many wills where that's condition precedent?
Yes, but not where, but in this case, the condition precedent has been excised as benefiting Carol. Just briefly, the consideration of matters outside the pleadings, the court addressed that. Was there were there additional matters to be addressed? Maybe, maybe not. The record of the discourse regarding this is found on page 3 and 4 of the trial transcript. In summary, the appellee consented to excise from the trial brief any statements, well, specific statements that the appellant and plaintiff said believed were offending statements as not part of the pleadings or outside of the pleadings. The court indicated, fine, I won't consider them. The court asked the appellant, then plaintiff, do you want to proceed? The appellant then plaintiff rejected or did not agree to convert that motion to a 12B6 from a 12C motion and responded specifically, as long as the court is not going to be considering factual allegations outside the pleadings, that we would like to go forward. To which the court again confirmed and also confirmed in the order that the court did not consider any allegations that were outside the pleadings. There is a little bit of overbleed between these two cases that the trial court here did or did not rule on whether Frank did attempt or did in fact revoke or amend his will. The way that this was pled through the declaratory judgment action first, where everyone agreed and stipulated that the will was valid before it was attacked by caveat. The court made a finding of fact, which again are not necessary and is not necessary to Your Honor's consideration, that Frank had died without amending or revoking his will.
And do you agree with Mr. McGuire's argument that we are not to consider the trial court's findings of fact?
I believe you're not bound to consider the trial court's findings of fact.
Do you think we should consider the trial court's findings of fact?
Well, no, I don't think you should. They were not required to be made in this motion hearing. But simply the fact that he did make findings of fact, and the fact that one of the findings he found was that Frank had died without amending or revoking his will, was cast in somewhat of a nefarious light. That may have had an improper influence on the court. But I would just submit that in order to have this declaratory action, we have to have a valid will. The validity of the will was pled by both parties. It was stipulated to by both parties. So,
are we now talking about the caveat action or the declaratory judgment action?
We're talking about the declaratory action. And just to briefly address the matter outside the pleadings, that it is not a statement by any party outside the pleadings. It's an extrapolation of the court, because we have to have a decedent that did not revoke or amend his will in order to have a valid will. And everybody involved pled and stipulated to the fact that the will was valid. So that's a logical inference for the court to make without finding that on base of testamentary or evidentiary evaluation. Finally, the appellants argue that intestate distribution is more in keeping with the realities of divorce. And we've done a lot of talking about this 31-5.4, and we both agreed it's the meat of the case. A good statute sometimes cuts both ways, but generally keeps in line with the norm. And again, what I think this court must consider under these different intestacy theories is that in a majority of cases, the devisees will be denied the devices, and those devisees under the condition precedent theory will oftentimes be the testator's children.
But
because
in
that's
this
the
case,
natural
they're not.
flow.
In this case, they're not.
In this case, they're not, but it is a very, very common occurrence in will construction that is just the standard flow to my spouse, to my children, to whoever after those two major beneficiaries. The statute is not an estate plan, it's a stopgap measure. We realize if I dislike you enough to get divorced from you, I really don't want my stuff going to you. And so the legislator put this out there just to serve as a stopgap measure in that particular instance.
But if I don't like you so much that I want to get divorced from you, how is it consistent that I would like your family to have everything instead of my family?
Well, again, where are we going to draw that line? That is absolutely based on inference and conjecture. That could be. None of us sitting here today know the relationship between Elizabeth Chamblee and Frank.
We don't.
We don't know the relationship between a party and their children. But that's what the statute prevents, is having to make those kind of conjectures. And where do we draw the line for benefit? Is it in immediate family, as it is in this case? Is it in adoptive family? Is it extended family, business partnership, lovers? So the court would have to follow that theory, is going to have to make up this body of law to define where that benefit relationship is, as opposed to just taking it from the statute. If it benefits the ex-spouse, it is gone, whether it's the condition precedent, whether it is a provision that benefits them.
I know that you mentioned some of the cases that appellants submitted late as additional authority. And are there any other authorities that were submitted after your briefing that you want to respond to?
I reviewed them. There is some instructory language in the Texas case, but again, I don't think it's on point that this court needs to consider what they do in Texas. The bulk of those authorities did not delineate between the general will construction theory or contract theory. Conditions precedent are frequently upheld in both instances, but contracts and general will construction, as were cited in these authorities, were not subjected to the scrutiny, the strict scrutiny of 31-5.4 and having those conditions precedents excised. If there's no further questions, I'll conclude. Thank you.
All right. Thank you very much. All right, rebuttal?
Thank you. I would just want to emphasize a couple of points I think your questions made, which were very good ones. To begin with, under intestacy, the children do get 100%, which is
100%?
yes, in this situation. And then also the other question, I think, was the benefit question. And I think you all went over that to where I don't need to reiterate that. That item 4 does not benefit Carol. And in fact, I think a key part of this is that Frank knew what he was doing when he wrote this will. I mean, he specifically said that if Carol predeceases me, then this will happen. And the reason for that is, he was not thinking about divorce, and surely he would have thought that if he died and Carol still lived, she would be there with his estate to take care of the family. I mean, that kind of makes sense, and that's what Frank's will says. So what the suggestion, I think, from the appellees had to do with what the trial court said, and that is where the trial court wanted to remove Carol's name. And what I understand the position of the appellees is in favor of a former spouse somehow means if that name is mentioned, you just take that out of the will. Well, that's not what the statute says. That's engrafting onto the statute just like they're, I think, trying to do with in-laws, they're also trying to do with how this statute should be applied. And it is very clear. It doesn't say about remove names. It just says if it's in favor of the former spouse, it is revoked. And I think the questions from the court indicated that once just the condition preceding alone does not get there, because at that time Carol would not be around to get any benefit out of it. And I would like to also, Judge Inman, answer your question that I think you said you were going to pose to us anyway, and that is, if I heard it right, that if Carol predeceased Frank and they had a divorce, would item 4 be honored? And I think it would be. I mean, I think that's what Carol, that's what Frank wrote into that, because he knew that if Carol was still around, that she would be able to take care of the parents. So that's rational. I think that the key to this case is taking a clear look at a provision with a very clear condition precedent. It's unfulfilled. Frank wrote that into his will. The court should not supersede that. And the only other issue would be whether or not Carol is benefited by that provision, and the court has covered that in quite enough detail. So to conclude, we would say that the legislature, by having equitable distribution, intestacy, and the section in front of you all, 31-5.4, has taken care of the situation that we have in front of us. And I would also mention that while there's a lot of talk about what would happen under this or that or the other, our Supreme Court has noted, and this is in the Cofield case we cited, every will is so much a thing of itself, and generally so unlike other wills, that it must be construed by itself as containing its own law. So I think in this situation, we could talk a lot about things that didn't happen, but what we know is Frank put in his will that if Carol predeceased me, then these things would happen. But that condition was not met, and therefore to give accord to the will of Frank and to read the statute as it was written, the ruling of the trial court should be set aside and the declaratory judgment should be entered in favor of our clients, which would result in intestacy. And that's the only argument I have, unless there's a further question.
Okay.
Thank you.
All right, thank you.
Thank you very much.
Okay. And now we'll move to our second case, and with this same parties, same attorneys, well, sort of different parties, I guess, in a way. But if y'all are already ready to proceed. So, and as far as rebuttal time, is that the same?
Yes, Your Honor.
Okay. All right. Very good.
Understanding that if we don't need it, we will take
Absolutely, yes. Okay, then we are ready to proceed on our next case. The will caveat.
May it please the court again. In the caveat case, this is before the court on the granting of a 12b-6, so it would be as a matter of de novo review in law, although there's a little wrinkle in there that I did want to mention, and that is judicial estoppel was brought up and raised as a defense. And judicial estoppel is a discretionary matter. The trial court exercised no discretion, so I don't think that this court would have it to exercise its discretion in this matter. I think it is here on a 12b-6 and is therefore a matter of law.
One housekeeping matter, we did not receive the transcript of the hearing. Contract was made for the transcript. It was a responsibility of the court reporter to transmit to this court the transcript, and we didn't get it. So just highlighting that for counsel, that we don't have a transcript to check. Yeah. I'm sorry?
It was uploaded by the court reporter yesterday.
Thank you. We will be able to review that later. See that.
We appreciate the email that you sent us about that, we got from the court, that allowed us to take care of that housekeeping chore. Also, I just wanted to note that there was a motion to dismiss an alternative motion to consolidate appeals. You all granted the motion to consolidate appeals. I don't know that they're still arguing the other part of the motion to dismiss, but if so, we would rely on our brief as to that separate issue. There are several issues on the caveat. There are the questions of judicial estoppel, res judicata, collateral estoppel, and then the issue of whether Leah can be both a propounder, rather a caveator, and an administrator.
As I don't have the benefit of the transcript yet, was election of remedies brought up as an equitable?
It was not.
Thank you.
That affirmative defense, I don't believe, is in the case. So I would like to start, if I can, with the judicial estoppel argument, because that, the contention there is that by our actions, or our client's actions, in filing the caveat after the decision was entered in the declaratory judgment, that we have threatened the integrity of the judicial process. And that's an important statement, so I want to address that first. We believe that there's neither substance nor merit to that contention. And I'd like to, judicial estoppel is not to benefit a party, it's to make sure the integrity of the court has been followed. And the context of this, we think, shows that there's been no threat to the judicial integrity of either the trial court or this appellate court. And key to the arguments I'm going to make all the way down the line here are the cases that say this: you can only challenge the validity of a will by caveat. You cannot do that by declaratory judgment. Similarly, you can get a construction of a provision of a will by declaratory judgment. You cannot do that with a caveat. So throughout the argument I'll be making today, that distinction, which is set forth in the Rogel v. Johnson and the Britton v. Britton cases, I think shows why in this situation there was no estoppel and certainly no threat to judicial integrity. The question of the validity of Frank's will was not at issue in the declaratory judgment action and could not be at issue because of the distinction that the cases make. A caveat is a statutory proceeding. Declaratory judgment is similar, but they have different procedures. I mean, you think about a caveat, it's a matter for a jury. It's can be a lengthy, expensive kind of a procedure. The declaratory judgment action is to construe but not determine the validity of the will. And the caveators, our delay in filing the caveat was reasonable under the circumstances. As I say, the issues in the caveat were not in front of the declaratory judgment court. And the testator's intent is by the four corners of the will. In a caveat, it's open to all sorts of issues as to what intent may be. The declaratory judgment action was filed, and it was not in our favor. So we did file the caveat because there's some evidence, we think sufficient evidence, particularly if we get into discovery, to prevail. But as I mentioned earlier in this, it would be our view that if you rule in our favor on the declaratory judgment action, that the caveat issue is moot. I think the most central reason, other than just the context and the fact that there's no threat to judicial integrity in this case, is that in the caveator statements do not reflect inconsistent factual assertions. And the factual assertions is really a key thing here, because in the Whitaker case, the very lengthy case that has to do with every kind of estoppel known to personhood, it also concluded that in judicial estoppel, It has to be factual assertions. That's different from these old cases. That's what our Supreme Court has said applies. And the appellants have made no factual assertions in the declaratory judgment action regarding the validity of the will. You can look at the pleadings, you can look at the hearing. That issue did not come up.
Paragraph 9 in your complaint in the DJ
Yes.
action reads, Frank's last will and testament dated March 22, 1983, a copy of which attached here too as Exhibit 1 was admitted to probate as being administered in New Hanover County and has a file number.
Correct. And admission to probate determines the validity of the will pending any caveat. And the North Carolina statute allows 3 years for any person that has a financial interest in the will to file the caveat. So when we were alleging that it had been probated, we were not alleging that the will itself was valid. That was a factual issue in the declaratory judgment action. Now, the probate itself established what I would call the conditional validity of the will until there is a caveat. But we did not allege anything other than the will had been probated, which we needed to allege as a preliminary fact issue in a caveat case.
The fact that you've you brought a declaratory judgment action at the outset doesn't affect the fact that there wasn't a valid will from your position in regards to the caveat?
That's correct.
Interesting.
Again, the declaratory judgment action is to construe the provisions, particularly item 4, could not determine one way or the other. And I believe it's in the caveat where we lay out the history of how this happened. When I'll refer to as Leah, the sister applied to be the administrator, there was no will, didn't know where the will was. And then it appears anonymously in the clerk's office. And at that point, we began to see reasons to have a caveat. But we did not plead the validity of the will. And in fact, it could not have been in front of the court in the declaratory judgment action. Because a declaratory judgment action in the cases that we've cited, it's been error found if a declaratory judgment action even assesses the validity of the will. That's for the caveat and only for the caveat.
Would it be possible, because I realize they're very different actions, but often, we'll have things where things are pled in the alternative.
Yes.
Would it have been possible to even bring an action that was a combined action saying, basically in the declaratory judgment portion, this is the will and we think it means this, but in the alternative, if it turned out that the will is not valid, this?
I've thought about that, and I don't see how that could be done because they're two separate proceedings under different statutes. The issues are different. I mean, they can't even consider the same issues. Now, I guess we could have filed those contemporaneously, but I don't think that we could have filed them in the same action because they're different proceedings, different procedures, different remedies, different law, all of that. And a case that we've cited here is the In Re Will of Shepherd, 2014. And we think we didn't emphasize this as much in the brief, but in that case, it was similar to where the caveator had made statements in a petition for an elective share that the decedent died intestate. Is that a factual assertion? You could think it was. The court said no. And the caveator said her last will was probated. That's exactly what we alleged in our declaratory judgment action. And in Re Will of Shepherd in 2014, the court said those were not factual assertions. And so we think that case is important on the facts of that case to show that as in that case there were no factual assertions, that there were none that we made in the declaratory judgment action. I think a very close parallel, if not exactly a case on point. So to conclude, there were no inconsistent factual statements that could have supported judicial estoppel. And then we turn to the next kind of estoppel that has been argued in this case, and that is res judicata, better known as claim preclusion. And the essence of the argument here is these claims are different. I mean, I've already said earlier that in one action they couldn't, in the caveat action, they couldn't construe the will. In the declaratory judgment action, they could not, and it's been reversed if they had tried to determine the validity of the will. These are different statutes, different elements, different judicial processes, different remedies. So under res judicata, it's very hard to see how you could argue these are the same claims. They're different in so many ways. And the declaratory judgment action, I mean, they both do have an issue of intent, and I think that was an argument that the other side made, but it's very different intent. The intent in a declaratory judgment action is what did Frank mean at the time he made the will from the four corners of the will. In a caveat action, it is what was intended when there was some revocation that is the basis of the caveat. In this situation, not only do we have the fact that the will was sent in anonymously, but we have a copy of the unsigned copy of the will in which the testator in his own handwriting wrote void. So we have different evidence, but the question of intent is entirely different in the two cases, just as the process and the statute and the remedies.
If I can just ask you, I'm just looking at the transcript now, I can see that counsel for the appellee did argue as follows. I would say that these parties certainly chose not in the choice between their two legal remedies there at the time, they chose not to file a caveat and challenge the validity of the will. They chose to come to court, file a declaratory judgment, and say the will is valid, specifically when the judge asked all the writings, all the filings as well. In the Whitaker case, there is a discussion of estoppel by election of remedies. The doctrine precludes the assertion of inconsistent positions by confining a person to the position which he first adopts. Thus, a party asserting rights under a will, deed, or contract is estopped by claiming under it to attack any of its provisions. One who accepts the term of an instrument must accept the same as a whole. One cannot accept part or reject. And that's from Whitaker. Assuming that this portion of the transcript, which I don't see in the written record, refers to the election of remedies, would you agree that that is an equitable bar to the caveat?
Well, no, and I don't think that was referring to election of remedies. I think there was an argument, we heard a wisp of it in the earlier argument, that we had somehow stipulated to the validity of the will, and that had to do with an exchange over whether to proceed with the hearing in the declaratory judgment when the briefs had all sorts of extrinsic evidence. And so we agreed if the trial court will not consider those, we will proceed. That colloquially, that exchange did not say anything about stipulating to the will. Now, as to election of remedies, it was not raised in the pleadings, and I don't think it was raised in that transcript. But I don't think that these two remedies are inconsistent. We could have, at the same time, you could follow our view on the declaratory judgment. If you did, it would moot the caveat. But if the caveat went ahead with, it would come to a different conclusion, a different remedy. The remedy that we were asking in the declaratory judgment action had to do with looking at item 4 and deciding that because it was unfulfilled, it sent the distribution into intestacy. The remedy that we are looking for in the caveat would be to declare that the will would be invalid as a result of the evidence of the modification by the testator.
Okay, and that's why that additional evidence, the document has void written on it, all that had no bearing on the deck action, but was brought in the caveat action?
Correct. We did add the caveat as an appendix in the deck action, just so the court, if you were considering it separately, would know what that was. But no, it does not have a result. I mean, I think the practical remedy we are hoping for is the declaratory judgment, because the caveat is so much more extensive. It's very divisive to the family. It takes a lot of court time. I mean, anyone looking at this case would say that the preferred remedy, if it were to come out in our favor, would be the declaratory judgment action, and that would be better for our clients, for the other side, even for the court. Finally, dealing with the issue of res judicata, I want to cite the estate of Cox case, this court in 1990, and it said that a declaratory action bars subsequent litigation only as to matters actually litigated. The declaratory judgment action did not litigate, could not litigate the validity of the will. Therefore, the doctrine of res judicata claim preclusion is not a bar. Turning to the next argument that they make is collateral estoppel, which is issue preclusion. And our fundamental argument is, as I said at the beginning, the caveat does not relitigate the same issues as the declaratory judgment. It could not, for all the reasons that I have enumerated. And that means that collateral estoppel does not apply. The issues are very different. And any time one declaratory judgment eggs in on saying something about the will, the Court of Appeals has said you can't do that. And I cited the Rogel case and the Britton v. Britton to that effect. The declaratory judgment action does not seek to ask whether or not Frank evidenced an intent to revoke his will, and the caveat does not seek to litigate whether item 4 is revoked under GS 31-5.4. The testator's intent when he made the will and versus decades later is very much different. So collateral estoppel does not apply. To summarize on that, because the issues are very different and they could not be the same under the two different statutes. Then there was an issue, the final issue, unless there's some question about judicial estoppel, res judicata, or collateral estoppel, I want to move to a different issue. That was an issue raised about whether or not the statute that allows the alignment of parties in a caveat precludes Leah from being a caveator as well as being a defendant administratrix of the will. And for the most part, I would rely on the briefs on that, but I do want to just make a couple of comments about that. For one thing, the alignment of the will was decided at a hearing before the clerk. That's always the case in a caveat that's kind of a preliminary matter that you get to. They're really complaining about that without having made any appeal of that alignment of parties. But fundamentally beyond that, we say that the alignment of parties was fine. If you look at that statute, it does not say anything about you can't be a caveator while you are an administrator. And in fact, the history of how this happened is something that we've already explained in terms of Leah not knowing that there was a will out there at the time she applied to be the administrator. And she wasn't designated originally, it was Carol, but Carol couldn't serve because of the statute that we talked about. So the statute itself does not preclude someone being on a caveator as well as administrator. And in fact, the statute says that any person with an interest can bring a caveat. Well, in this situation, it happened that after not knowing that there was a will would be sent in anonymously, Leah applied to be administrator and then found out about issues that led her to be a caveator. And the precedent that we have cited for this is the Will of Charles case, the North Carolina Supreme Court case in 1965, and it said that any interested person may challenge the will and contest its validity by filing a caveat. And the language of the statute doesn't say otherwise. And then in the Will of Covington case, the North Carolina Supreme Court case of 1960, the executor became a caveator after finding a later dated will. There's a little difference there on finding a later dated will and finding an unsigned with void across it and someone sending in the original. But the point of that is, according to the North Carolina Supreme Court, it is fine to be, or it doesn't probably happen too often because this is an unusual set of facts, but the fact that you are an administrator and then learn facts, whether it's about a later will or whether it's about a caveat, There's no reason under that statute while Leah would not be able to serve in both positions. So to summarize on the caveat, we don't think that the judicial estoppel, res judicata, or collateral estoppel applies. We argue that Leah can be a caveator and an administrator. And so the remedy that we're asking in this case is to reverse the trial court's dismissal pursuant to 12b-6 and remand for further proceedings in the caveat unless this court finds the caveat issue to be moot based upon your ruling in the declaratory judgment action.
I can just ask you, because unlike the deck action, the procedural background here is all part of the case. Make sure I understand. When Leah applied to be the administrator, you said that she did not know about the will. Is that correct?
That's correct. I mean, she had an unsigned copy. No, that came later. No, she did not.
She didn't know anything.
I believe that's correct.
Okay. Then there's an anonymous message, or the will is there, and she finds out when she goes, oh, there's a will. When, relative to the deck action, did she find the will that was marked void?
I believe it was prior to the deck action. May I ask Ms. Euler, who was in there in the case? It was before.
I have a question, and then question, does it matter? And I think you've answered this, but just to make sure I've got it. The reason your clients waited to file their caveat action until after the deck action went to judgment, my understanding from you is that the deck action is just a much quicker remedy, just a quicker, faster remedy. Is that correct?
That's part of it, but it's also, a caveat is a much, very contentious proceeding. I mean, obviously the in-laws, there was some estrangement there already, but it's a jury trial. There are a number of reasons why one would want to prevail in a deck action and have the expense and the length of time. And quite frankly, we thought the deck action was pretty clear reading of the statute and the will. And there may have been additional facts that came out, but I think essentially the clients did know about the unsigned void will at the time of filing the deck.
But if your clients had chosen to bring the deck action and the caveat proceeding at the same time, would then the deck action be attached to this wagon of alignment of parties and everything that goes with a caveat proceeding? I'm just trying to understand the strategy.
I don't know that it would have been tied together that way, but our position is we could have brought them one in front of the other or at the same time. I expect that once the clerk's probate procedure were appealed to the Superior Court, that might have been a point at which the Superior Court could have consolidated those for hearing, much like this court has.
Very good. And we're going into your rebuttal time, so I don't mean to take...
And the final argument, and then I'll sit down on that, is that there was no prejudice whatsoever in this case by the order in which or the timing of which they were filed. Thank you.
Okay.
Again, may it please the court, for the record, I'm Dave Urban, New Hanover County Bar. I represent the appellee, Peggy Johnson, in this matter.
Let's get the timer reset here.
Yeah.
Oh,
There you go. Okay. Can I ask you a question, Mr. Urban, just before we get started? Mr. McGuire has argued that if this panel were to agree with his argument and remand the deck action for entry of judgment in favor of the appellants, that the caveat proceeding would be rendered moot. Do you disagree with that?
no, Judge. I think he's exactly correct.
Okay, thank you.
I think that goes to the heart. I think Mr. McGuire very clearly covered a lot of the law behind this, and as I said earlier, a lot of that law is also in both of our briefs. But I think the fact that the deck action would make the caveat moot is at the heart of why the appellant should be judicially stopped from making that argument now. They had that information.
Why would it be moot? The argument from the appellees has been that we could bring both of these at the same time. We don't have to take a position in regards to the validity of the will to have a declaratory judgment action. If they win the DJ, how is that caveat proceeding not still hanging out there?
Well, that's true. I guess maybe rather than being moot, maybe the caveat would be brought from our side or from another interested party. Because if they win the deck action, then the entirety of the estate goes to Frank's siblings in intestacy. So there's no reason that anybody on that side of the V is going to challenge the validity of the will under the caveat.
Sounds to me like you're trying to take both sides of the coin, where if we win the deck action, then we stipulate that the will is a valid will. If we don't, then we'll need to proceed with our caveat.
Yeah.
And you're basically on the other side of that,
Saying,
depending on which way the deck action comes out.
yes, saying if you have valid concerns that this will is not valid, you elected, rather than filing them concurrently, as you said, or filing a caveat to test the validity before we test the meaning of what we don't know is valid yet. Why was that information about the caveat stuck in the vest pocket and kept it close? Let's play and see if we can win at the deck action, because it is faster and cheaper, and it is 100%. So,
And is that, I just want to understand too, and I'll ask you about the election of remedies estoppel and whether or not that was in the pleadings, I don't know. Well, I'll go ahead and say, do you disagree with Mr. McGuire's argument that judicial estoppel, collateral estoppel, and res judicata do not apply here based on in re will of Shepard and Rogel and Cox?
now, I believe that there are factual allegations that are made in the declaratory action by stating that the will is being probated and it's valid as the propounders of the will. I don't think for the reasons that he stated that is correct, because I think they did take a very opposite position there, and they're taking an opposite position here today.
How do you distinguish in re will of Shepard? Which held that assertion, which held that the proper execution of a will is a mixed question of law and fact.
Well,
So that the caveats or statement that the decedent, in that case, actually said died testate and that her last will was probated are not factual assertions as to the will's validity, and therefore judicial estoppel is not applicable in this case. Can you distinguish Shepard?
well, in this case, the same parties, the same side, is claiming that before they filed a declaratory action, they had reason to believe that the facts supported that the will was not valid. Yet, they continued on a separate path that we are going to, again, intentionally or not, hide the ball and keep that argument close to the vest to see how we do in the first argument. So it's a
And all these equitable doctrines are, Mr. McGuire argued that they are to protect the integrity of the courts, not a party. Do you agree with that, or do you disagree with that?
Well, in part. I mean, Price versus Price said that the purpose is to protect the integrity of the courts by preventing the litigants by playing fast and loose with the rules and deliberately changing positions according to the exigencies of the moment. And I think that flows through to the process and to the litigants also by doing that.
And is strategically ordering litigation in a way, at least Mr. McGuire has argued, was for the purpose of saving money, saving time, and holding the caveat action, as you said, in their pocket, or waiting to take a second bite of the apple, or any other analogies we could make. Is that in and of itself lacking integrity, disingenuous, dishonest, undermining judicial administration?
Well, I think it can be, and I am not casting that aspersion specifically here, but the nature of what we're talking about, we have reason to believe that this man tried to change his will, that this is not valid, that there is something else going on here besides what we're going to try to get the court to respond to in the declaratory judgment action, but we're not going to put that forth, I think is why that the appellant should be stopped from making that argument now. It was available, and it is taking a totally different position that it's not valid than was taken in the declaratory action, which at best was silent. But in order to get to a 12C hearing, there have to be no facts at all that are in contention. And we're asking the court, we agree on all the facts here. Court, can you apply the law to this for us? And that's what we did. Now, keep in mind, too, that they filed the declaratory action. They filed the first 12C motion. So it was a very clear position. The will is valid. Everyone agrees. The will is being probated. The will says this, it says this, it says this. Everything was agreed and stipulated to.
Well, again, so do you disagree with Mr. McGuire's assertion that case law says the trial court in the DEC action lacks subject matter jurisdiction to resolve the validity of the will?
Yes, but it shouldn't have gotten to that point.
So you think that in a DEC action, the trial court does have jurisdiction to resolve an issue about the validity of the will?
No.
You don't?
No. The trial court, as Mr. McGuire said, that is an issue to be had through a caveat.
So if the trial court in a DEC action doesn't have subject matter jurisdiction to resolve the validity of the will, how does the prosecution of the DEC action by the plaintiffs, and I think you said they brought the motion for judgment on the pleadings first, how is that inconsistent with challenging the validity in the caveat action?
Well, the position is inconsistent. To get to the DEC action, you need to file it. The filing party is saying, this is the valid will. We need the court to weigh in on it. By filing a 12C motion, all of the facts regarding this, the will, its validity, what it says, they're all established.
So the validity of the will, again, you're saying the pleadings assert that in the DEC action?
The pleadings do assert that.
Okay. You have a motion to dismiss based on the untimely appeal. Do you wish to be heard on that at all?
Judge, I withdraw that.
Thank you. Okay.
Thank you. The will had to be admitted to probate in order to file a caveat. The caveat is the proper way to challenge a will. The reason that the appellant should be judicially estopped is because of the fact that they actively took a position when they had different positions based on different factual contentions. That argument that there's not a factual contention there is disingenuous, even if it's just by omission. If you did, as the filer of this declaratory action, have knowledge of all the facts that you have pled in this amended, in the caveat, the amended caveat.
So would you argue that we should overrule In re Shepherd, In re Will of Shepherd? Or isn't that something for the Supreme Court to do and not this court? Aren't we bound by In re Will of Shepherd?
Well, to the degree that this court finds that the factual similarities require that, I'm not sure that it does.
Oh, how is it different? How is it different, factually?
Candidly, I'm not astute enough, learned enough today on that, but if the court would like, I would be happy to prepare a supplemental response within 48
Not
hours.
necessary.
So I'm just sort of thinking about as a practical matter. So Leah goes to file to become administrator, thinking there's no will. Finds out that something is there at the clerk's office, has shown up, and I'm not sure what the timing is, but anyway, something shows up saying it's a will. And let's say she had said, you know, for whatever reason, that's fraudulent. You know, I believe he's intestate, and I want to proceed as administrator, as intestacy. I mean, something's got to happen there, right? The clerk's got a document that says it's a will, whether she thinks it's valid or not. I mean, so,
She, or
you know, somebody is like, then what happens? She's like, well, I don't want to file a caveat because, I mean, this shouldn't even be admitted. It's just not even a thing. I mean, what happens?
Leah or any interested party has 3 years to file a caveat based upon that.
Right.
But that's not what I think Leah did. Leah looked at both sides of the coin and said, which is the pitch we'd rather hit here?
Of course, right. But I mean, it's just, you know, it's like, I mean, there's such different things. I don't, you know, it's like what, at that point, the will is filed, and then you've got to take you know, you've got to proceed with it somehow. It's a strange thing, because like I said, the procedures are so different.
Correct. Yes, we believe that all of the Estoppel arguments basically come down to the fact that we're either taking inconsistent positions, or we have already determined this issue is that the will is valid. Now the appellants are doing a 180 and saying, well, the will's not valid. But they're still saying the will's valid because they're still appealing the DEC action. So this is not even a second bite at an apple. This is a concurrent bite at the same apple. It's not a prior inconsistent position. It's two inconsistent positions right now. Can you, as the Court of Appeals, reverse both of these without finding that the will is valid and the will is invalid?
Go back to the question I think I asked and Judge Carpenter asked. If this court were to reverse the trial court's judgment in the DEC action and remand for entry of judgment in favor of the plaintiffs, we have the caveat proceeding. It's going on. You said it would be moot. Mr. McGuire said it would be moot. But how procedurally does that action go away? I mean, is it even possible for the caveators to file a voluntary dismissal? Can the propounder keep it going? And then I guess the other question I have is, if this court agreed with the appellants, you said something about, well, maybe the roles would be reversed in the caveat, but your clients wouldn't benefit at all if the will were determined to be invalid, right?
That's correct.
They wouldn't benefit if the shoe were on the other foot. They wouldn't want to challenge the validity of the will.
That's correct. I'm assuming whatever is in this caveatable will there may be somebody in there that is now an interested party, because if the caveat will becomes the actual will, and that may change the game. Yes, if, I think the original question was, if the court enters judgment in favor of the appellant on the declaratory action, does it make the caveat fight moot? I think most likely it does, but it does between us. Now, it could go back. This case could go back and go on if the deck action is affirmed and the caveat is reversed. And then we're going to go back to having the real argument on what really happened to this caveat.
And that's when we get into the real issues of with all the outside evidence of the second document and all that. We don't need to think about that until we're in the caveat action, right?
Correct.
Okay, thank you.
Correct. So I don't want to belabor by breaking down each individual estoppel argument. We did cover those, and we'll rely on what we had written to the court in our briefs. We would ask the court again to consider that there was a final judgment on the merits of whether the will was valid. Now, it was judgment by stipulation, by agreement, but it was still a judgment. That was claimed between the same parties regarding the same claim, and that is the will valid? Yes, it is. No, it's not. The fact that we weren't asking, or that the deck action didn't ask to declare specifically that the will was valid or not, as Mr. McGuire said they couldn't, it doesn't mean it wasn't judicially established, and it doesn't mean that it wasn't put forth by the appellants as well as by our side to get to competing 12C actions.
And does that estoppel apply not just to Leah, who was the administrator, but to her brothers?
We contend that the appellants as a whole are stopped from taking a different position than the prior inconsistent and actually a current inconsistent statement. In the record, we point out the trial court even said something to along the lines of, do I have everything I need to decide this issue? And everybody agreed, yeah, you do. We're all in total agreement on the factual posture of what's going on here.
This is in the caveat proceeding?
That's correct, Judge.
This is in the caveat proceeding
Or in the deck action?
or in the deck action?
In the deck action, I'm sorry.
Okay, thank you.
That makes more
That's
sense
okay.
to me.
Yeah.
I'm glad that you were listening for me. Judge, beyond that, I will rely upon what we have written in our brief, unless there's further questions from the court.
Thank you.
Nothing? All right, thank you.
Thank you, Judge.
Rebuttal?
May it please the court, I would first like to disagree that there was anything in the deck action like a stipulation as to the validity of the will. I think that argument was made at the hearing. It's not been made in the appellate brief in this court, so there's no citation in the record in that transcript to where that so-called stipulation occurred. But I'm almost certain it was, as I mentioned earlier, when Ms. Euler was objecting to the outside evidence coming into the hearing, and the trial court said, well, I will only consider not any evidence that is outside the record. Are we ready to proceed? Do we have everything? Is that clear? And Ms. Euler said, yes, that had nothing to do, that exchange had nothing to do with the validity of the will. And in fact, back to the very initial point I made, the declaratory judgment action cannot determine the validity of the will, and in the cases where that was tried to be done, I cited Rogel and Britton v. Britton, that was not allowed. These issues are separate by statute and by decision. And I think it goes also to the reason of the question of the estoppel. And Judge Inman, I just wanted to make sure I was clear. The judicial estoppel is the one that goes to the integrity of the court. The collateral estoppel, res judicata, that would be for the protection
Of the parties. Thank you.
Yes. And on this issue of inconsistency, I wanted to mention two cases cited in the additional authorities, and they're cited in the Whitaker case, and they're on the issue of quasi-estoppel, and that's not been argued in this case. But I think these cases are helpful to trying to understand this whole idea of which you can do it at which time. In the will of Smith and in the will of Peacock, in each of those cases, this court, one in 73 and one in 2003, held that a beneficiary's acceptance of a bequest does not prevent a later filing of a caveat. Now, in the Peacock case, it was a bequest was preliminarily accepted by one of the beneficiaries. Later, that beneficiary filed a caveat, and the court said that there was no estoppel there. Similarly, in the Smith case, it's the Chevrolet case where the beneficiary accepted a Chevrolet and then later filed a caveat, and the court said there was not. It was quasi-estoppel, but I think those arguments are kind of helpful to understand the fundamental point we're making here, which is that these proceedings are so different that you might file them at the same time, but there's no reason, given the 3-year statute of limitations on the caveat, that we could not file that later. And I think the judicial estoppel, it's very specific to, they have to be inconsistent factual allegations, and I think the in re will of Shepard absolutely is on point, because there is here the later caveator said earlier that the will had been submitted to probate, and that's exactly what we've said in this case. We don't see an inconsistency there. And I would disagree that you really do have to look at these estoppels differently because they have different elements. And what we're saying on the judicial estoppel is different than the other two. On res judicata, we're saying they're different claims, and I've made that argument. On collateral estoppel, we say that they're different issues, and I've made that argument. And the courts have said that declaratory judgment is not to, doesn't keep you from arguing those. So I think you do have to look at those separately, and I expect that the court will. But overall, I think there is no estoppel given the separateness of the proceedings. And one additional thing that occurred to me in terms of the earlier question was, if they both were filed at the same time and the clerk's action and the caveat were appealed, a court could stay one or the other, kind of depending upon how it might look. So there are practical ways I think that could be handled. But there was no stipulation as to the validity of the will. We allege that in the deck action only as a background fact, which Will v. Shepard says does not get to the estoppel.
How do we side with you on this case in the context of a 12C and not make a determination in regards to the validity of the will? How do we do that?
You're talking about in the deck action or the caveat?
In essence, if we rule for you in the deck action, aren't we making a statement that, hey, this will is valid?
You'd be making a statement that you would not have to make that statement.
How do we do that in the context of a 12C? How do we do that without in essence, assuming that there's a stipulation as to the validity of the will?
Well, again, that we strongly contend that there was no such stipulation. It was merely saying that the will, we acknowledge that the will had been probated, and in the exchange in the transcript was not on that issue. But I think your question, as I understand it, is if you rule for us in the deck action, what would happen with the caveat?
No, that's not exactly my question. I have a pretty good feel for that. In essence, there was an action brought in Superior Court to say, interpret what this document says for us. And now on appeal, as an alternative theory, the argument is the document that we presented to you to interpret as to this subject matter, Judge, was not a valid document and was not authentic.
That's our claim.
Does that create issues?
I think it would leave an issue that has already been raised, as practically speaking, what would happen with the caveat. I don't think it raises another issue, because we could have prevailed in the deck action and gotten a favorable ruling that would moot the caveat.
If the parties were different, if the parties were different and parties on both sides of the V in the deck action were intestate heirs, would be intestate heirs, and the plaintiff prevails in the deck action, the defendants who would be intestate heirs lose, and then they go and file a caveat proceeding. Is it possible that through the caveat proceeding, the outcome of the deck action could be undermined because the entire will could be determined to be invalid?
It'd be a different ruling, but the caveat,
The deck action would not preclude the caveat proceeding from going forward and basically snatching the victory away from the plaintiffs in the deck action.
correct, because the deck action could only construe, could not determine the validity of the will. And as a practical matter, I think that if you rule in favor of the deck action, there'd be a remand on the caveat for determination inconsistent with that ruling, which would be a dismissal, is the way that I would see that. So on the caveat, we think the estoppels do not prevail under looking at each different one, and I think the essence of what we're arguing is the proceedings are very different, and there's no reason we would not be able to bring one proceeding at this time and one in another, and it was reasonable that we did that which we have the deck action decided first. If the deck action had been decided in our favor, there would have been no reason to file the caveat, and we had 3 years to make that determination. But it was not ruled in our favor. We thought it would be, so we did need to look at bringing the caveat. There's no inconsistency in that under in re will of Shepherd, and therefore we would ask that you rule for us in the deck action. If you did not do that, I think the caveat action should be allowed to move forward. Thank you for your consideration.
All right, thank you. Thank you very much for your arguments. And we are going to take we're not going to adjourn court, but we'll take a brief recess to get ready for, we're going to be doing a swearing in of a new attorney. So we're going to take a little break, and then we'll come back and do that.
We're released.
Yes, you will.
Released.
Unless you want to
Unless you
come
wanna
and
watch.
watch.
You want to
swearing
watch?
in. Yeah.
Thank you
It will
for
be
your
much
excellent
less
arguments.
contentious. All right. So,
Court is in recess.
thank you.
Thank you, Gene.